beginning, we have framed the issue. The instant interlocutory application seeks to revisit the principles governing the determination of seniority within the cadre of higher judicial services of all the states. We have traced the history of various judgments of inter-se conflict between the direct recruits, the promoters, and after the 1992 judgment, 2002 judgment about the LDC, LCD. And we have referred to a quote from the first All India Judges Association. Judges do not have an easy job. They repeatedly do what the rest of us seek to avoid, make decisions. Conclusions. Before proceeding any further, we consider it to opposite to record the caveat that the guidelines issued herein are not intended to adjudicate or resolve any inter-se seniority dispute amongst the regular promoters, the LTC, and the direct recruit. What we seek to lay down are general and mandatory guidelines which shall henceforth be incorporated into the respective statutory services governing the determination of inter-se seniority amongst officers appointed from different sources to the higher judicial services. Likewise, the directions issued herein shall not be construed as an avenue to reopen or unsettle inter-se seniorities that have already been determined between the officers appointed from the different sources of recruitment. It is further clarified that such directions as well as this judgment in total are being issued considering the issue as on date and may require reconsideration upon observing the ultimate impact and effect of the decisions rendered by the Constitution Bench in Rajneesh AV and the 6th All India Judges Association. This is so being mindful of the fact that the inter-se position amongst the regular promoters, the LDCs, and direct recruits is likely to undergo substantial change in due course in light of the opposite decisions. Such altered circumstances may necessitate a review, modification, or recall of the present direction. In this way, we deem it appropriate to invoke our powers under Article 142 of the Constitution to record the following conclusion and issue the ensuing direction. That pursued discontentment and heartburn without something more in the form of a legal claim, illegal denial, or at least a legitimate expectation cannot result in creating an artificial classification of members within a cadre. That the statistical data is disparate and does not provide a substantial basis to find such discontentment and heartburn of regular promoters in the edges to be justified. That there is no common malady of disproportionate representation of direct recruits in the edges such that it is diminishing the prospects of financial upgradation or designation as principal district judge to the promoters, which affect the country as a whole, or make it imperative for this court to resolve it by giving a preference to the regular promoters and LDCs. That the data put forth in many states indicate a prevalence or equivalence of regular promoters in IJS and key positions, which is natural since their ratio is 3/4 of the total force in the cadre. That on the entry into a common cadre from different sources and assignment of seniority as per the annual roster, the incumbents lose their birthmark of the source from which they are recruited. That fixation in the selection grade and superintendent scale within the edges is based on the merit cum seniority within the cadre and cannot depend upon the length of service or performance in the lower ranks of the judiciary. The latter loses its significance after RPs and LDCs by its virtue are propelled into the edges. Reliance on it does not serve the object of efficient administration of justice and is counterproductive. That the length of performance as a civil judge also does not constitute an intelligible differential to classify incumbents in the common cadre of district judge and the classification made in Tilokinath Kosa by a constitutional bench of this court on the basis of educational qualification stands on a different footing. Their individual career aspirations are a normal incidence of service, accentuated only by better performance. They are not connected to the objective of an independent and strengthened judiciary and cannot guide the shape of the rules of seniority. That sufficient accelerated opportunity are provided for members of the judicial service entering into lower ranks for career advancement as provided by the Constitution in Rajneesh KV, enabling the reckoning of their service for direct recruitment to HJS, and by the 6th AIJ, facilitating fast-track promotions to civil senior division and the HJS through reduction in the minimum period of service. That the seniority of officers within the HJS shall be determined through an annual 4-point roster filled in by all officers appointed in the particular year in the repeating sequence of 2 RPs, 1 LDCs, and 1 DR. That only if the recruitment process is completed within the year, after which it was initiated, and no other appointment from any of the 3 sources have already taken place in respect of the recruitment initiated for that subsequent year, shall the officers belatedly so appointed be entitled to seniority as per the roster of the new year or roster of the year in which recruitment was initiated. That if the recruitment process is not initiated for vacancies arising in a given year, in the same year, the candidate filling such vacancy in subsequent recruitment shall be granted seniority within the annual roster of the year in which the recruitment process is finally concluded and appointment is made. Then after the recruitment of direct recruits and LDC is complete for a particular year, the positions falling in their quota that prevent unfit due to lack of suitable candidates shall be filled through RPs, subject to such RPs being placed only on subsequent RP positions in the annual roster, and the vacancies in the subsequent year shall be computed so as to apply the proportion of 50, 25, 25 to the entire cadre. That the statutory rules governing the HJS, the respective state, in consultation with the High Courts, shall prescribe the exact modality of the annual roster and how the directions of this judgment shall be implemented. The respected states, union territory, administration are hereby also directed to undertake appropriate amendment to their respective statutory rules in consultation with the High Court to bring them in consonance with the guidelines laid down in this judgment within a period of 3 months. The questions framed by us is thus answered in the above term. The incident will be ability stand dispose of. I number swans and swans also stand dispose of.
This is what I had done. What is accepted?
I'm grateful to all of you for your valuable assistance. I am grateful to all my learned brothers, particularly one of us who has taken pains to write it down. We have to honor his wish.
We are grateful for the judgment because this has been good guidance. We held our briefs, but your lordships, the result is a very balanced process, which we will see, and especially.
I don't know what will happen in a couple of years, so that's why we observed that.
Very grateful. Very good. Very grateful.
Grateful.